So now we're going to talk about the anatomy of a complaint, and we're going to go through a template complaint that I have used for a bunch of my cases. It's an asylum delay complaint, specifically for Turkish cases involving followers of Fethullah Gulen, who I've represented a lot of these people, so I developed this template, which I've used in dozens of cases. There's lots of templates available online if you just do a Google search, or AILA maintains a pleadings bank of sample complaints and motions and arguments and things like that. So you're going to hear Brian's perspective too. Brian doesn't like this, so he's gonna. If he thinks I could do something different,
there's no right or wrong way to do it.
He's gonna tell us. Yes.
Yeah, it's just a question of style.
I would say when I started doing federal court litigation, coming from immigration court, there was this tendency to want to try to prove everything using affidavits, right? Like proving every word in every pleading. So the first thing that you'll notice in a complaint, you don't have to prove things in a complaint. You just get to say them, all right? And then...
they're allegations.
Yes. And then the court will assume that they are true for the purpose of a motion to dismiss.
And the government will file an answer that affirms, denies, or says they cannot affirm or deny every paragraph. Right. So part of what you want to do in a complaint is you want to break your statements, your allegations, into paragraphs that are so discrete that they're really one topic, and you want to try to force the government into agreeing that something's true. They'll never do it. They're going to say, we deny everything. But if you really want to go back to the classic idea of a complaint, it was to cage your opponent into admitting as many facts as possible.
Right. So let's see. Complaints don't have to be that long.
Yep.
For like a FOIA case, you can do a complaint in 3 pages, right? You'll see this delay complaint is about 5 or 6 pages. That is plenty. Again, when I first did this, my complaints were 15, 20 pages. I was writing everything. You don't need to do that. Also, one other thing about complaints is you don't need to write pages and pages of legal argument. A complaint is not really a super appropriate place for detailed legal argument.
You're not going to win a judgment off the complaint.
Right. Now, if you read a lot of complaints filed by nonprofits in impact litigation, you'll see pages and pages and pages of legal argument. But for your run-of-the-mill case, you don't want tons of law.
Especially for delay cases.
Right.
I mean, you'd like the opposing counsel to be able to read your complaint, understand it in 5 minutes.
Yes.
And ultimately in negotiations, which we'll talk about in a different session, you kind of want to crib it for them and give them an email that summarizes an executive summary.
Right. And if they decide to fight you, you can amend your complaint. You can add content to it later. So for like a lot of delay lawsuits, you can start with a complaint that's bare bones, and then if you get a fight from the government, you can beef up your complaint and file a new one. All right? So keep it slim with your complaint. Usually, you don't attach a ton of exhibits.
I try to attach the operative documents only. So if I'm filing a lawsuit over a denial, the denial might be 10 pages. I'll give them all 10 pages. The RFE response on the I-140 might be 1,000 pages. Mm-hmm. I'm not going to give the judge 1,000 pages. Right. I'm going to give maybe just the cover letter that the lawyer summarized everything and it's 5 pages long. I want to give the minimum number of exhibits to prove the bare essentials. And if it's a delay case, you're talking about when did the delay start? What's the filing date? Has there been any action by the government? What's been the follow-up? Those 3 things are all you really need. And that's only if you really are talking about exhaustion remedies.
Right. Yeah.
So what parts of a complaint do you think are essential?
Right. So the most critical thing is to state the basis for jurisdiction, right? We'll get into that in a minute. But first, let's start with the basics. You have the name of the court, then you have the heading. You have to list the plaintiffs and the defendants. In some places, like I believe in Maryland, you have to write their addresses.
And DC.
In the caption, yeah.
Of every single party.
Right.
Even the defendants.
Right. So there's a spot for the case number. That's the case number in federal district court. We had a meeting with our local U.S. Attorney's Office recently, and we learned that they like the A number to be somewhere towards the beginning so they can easily find it.
I put the A number and the service receipt numbers in the caption.
Yes.
Because it's on page 1, and they're always going to need it.
Right. So then you have your title. Usually it's complaint for something. Maybe it's petition for habeas corpus. Maybe it's for petition for writ of mandamus, right?
People often put in declaratory injunctive relief. I don't think they're always really looking for injunctive relief. I think they just say it like it's a magic spell. I write complaint for Administrative Procedure Act relief. That covers everything.
You can also just write complaint.
Yeah.
Right. So then you have your first paragraph. This is your elevator pitch. You want to grab the reader's attention, let the judge know why they should care, who does this impact, who is this harming. Give a little bit about the basis for
one
your case.
sentence, a one-sentence summary.
Right.
Sometimes you'll put a heading introduction.
Right.
Or overview. You don't have it here, but that's what it is. It's a one paragraph. This is the party. This is why we're here.
Right. Let me go back one little tick. When you're deciding who to sue, and let's say you don't know who the government officer is. Let's say you don't know who the director of the Vermont Service Center is. You don't need to go and research that. If you want to, you can just list their title and sue them by their title. That's allowed by FRCP 17D. And I think that's really a good time-saving measure right now because a lot of these government officers are not Senate confirmed right now, and they're changing on a weekly basis. So if you name them and they're changing every week, then every pleading you file, you have to keep changing your template. If you just name them by title, you don't have to do that. All right?
Yeah.
All right. So next is your statement of jurisdiction. This is probably the most critical part. Courts are strict. You have to be strict in how you invoke the court's jurisdiction. You have to identify the statutory or constitutional basis. Yeah. That is absolutely non-negotiable.
The APA is not a jurisdictional statute.
Right.
So you might think it's an APA lawsuit, but it's really a federal question lawsuit.
Yes. So the most common source of jurisdiction is 28 U.S. Code 1331. That's federal question jurisdiction. That's for matters that arise under the Constitution, laws, and treaties of the United States.
That's a huge area, right?
Right. Now, there's two theories as to what is a federal question. First, the most commonly accepted one, least controversial, is your cause of action created by federal law? So if you're claiming an APA cause of action that's created by federal law, so then when you'll see in this complaint, I say this is federal question jurisdiction because it arises under the APA. All right. Now, a second type of federal question is, does the claim involve construing federal law? All right. Now, you don't want to rely on that type of federal question case. You'd rather have one where your cause of action is created by federal law, and then it's clear and uncontested that obviously this is federal question jurisdiction. But that's a second type of federal question case. All right. Now, some other different types of cases, you might have a different jurisdictional statute. Let me just go over a few of them. 28 U.S.C. 1361 is the mandamus statute, and that states its own basis for jurisdiction. For habeas, you have 28 U.S.C. 2241. That statute doesn't say the court has jurisdiction. It says courts may award the writ within their respective jurisdiction. I wish it was stated more clearly because...
That's more like the geographic jurisdiction.
Right. Typically, jurisdictional statutes, you know them because they say the word jurisdiction. They're supposed to be clear. I don't like that one is not clear. But anyways, for habeas, you can also claim the suspension clause because constitutional provisions... I haven't read scholarship on this, but the general practice is that the constitutional provisions can be enforced through their own cause of action, you know? Next, FOIA has its own jurisdictional provision, 5 U.S.C. 552 A4B. And then naturalization delays, 8 U.S.C. 1447b, that is a jurisdictional statute. So those are the 5 or 6 jurisdictional statutes that you're most likely going to be facing. In all likelihood, most of the time it's going to be federal question jurisdiction arising under the APA.
Or maybe cited to an INA section.
Right. I want to mention a little bit, all right, a little bit of dryness here, but let's talk about Twickball. All right, Twombly and Iqbal. These are 2 famous Supreme Court cases. These are probably the most cited Supreme Court cases. They lay out the pleading standard that you have to meet in your complaint to survive a motion to dismiss.
So you only see them mentioned in Rule 12 motions, really.
Yeah. So the first one is Bell Atlantic Corps versus Twombly, 550 U.S. 554. That's a 2007 case. So that first developed the new standard as applied to antitrust. And then 2 years later, Ashcroft versus Iqbal, IQBAL, 556 U.S. 662, 2009 decision. That applied the new standard to all federal civil litigation. The standard is that the plaintiff must establish a claim to relief that is plausible on its face. All right? The court has to accept as true all well-pleaded factual allegations for the purposes of assessing a motion to dismiss. So that's a wonderful thing. Remember, I said you don't have to prove everything in your complaint. All right? And the truth is, let's say you were trying to attach affidavits to prove up your complaint. It'd probably be hearsay and not really appropriate. So don't do it. Just state your allegations, make them clearly. Let's talk about what a well-pleaded allegation is. Let's say you're trying to prove a battery. You can't just say, he battered me. All right? You have to say, he struck me in the face with an open fist. That's a well-pleaded allegation.
And maybe on the street corner on 4th Avenue on Tuesday, June 1st.
Right. So the court has to accept this well-pleaded allegation if the other side files a motion to dismiss. If all you say is he battered me, that's a formulaic recitation of the cause of action or recitation of the legal standard. Court does not have to accept that.
The Supreme Court has moved away from notice pleading, and now it's not quite to the point where with fraud you had to plead with particularity. It's somewhere in the middle. So you're better off pleading more facts and more details, and you can attach to your complaint exhibits, but you can make them general, and you can point a citation to the document, but you don't have to get into, like, on page 3 they did this.
Right. And you also want to keep in mind, if you start doing a lot of exhibits, keep in mind what would be more appropriate to attach to your summary judgment motion later on if you need it, right?
And you aren't going, and at least in the APA lawsuits, if you're challenging a denial, you're going to have an administrative record, a certified administrative record. You're not going to be citing to your exhibits from your complaint. You're going to be citing to the CAR. And that's going to be a wholly different number of pages. You're going to have to redo all that work again.
Right.
So it's good to attach exhibits to create the impression that you're going to win. But if you spend 25 hours on it, you're not going to get a return from that work.
Right. The court does not have to accept legal conclusions that you state in your complaint, all right? But they do have to accept facts. So keep in mind your complaint should be focused on facts. If you make a statement of law in your complaint, the government doesn't even have to answer that. They don't even have to respond to that. So in a certain sense, it's kind of wasted material unless you really want, unless it's like something very novel.
If you're challenging a policy that is a legally operative policy, you can include it.
Yes.
But they're never going to agree to it.
If you're doing something some impacty litigation, you do want to state your full case up front because you want to win over the judge and the clerks.
But if it's a delay lawsuit, if you're filing over a denial of a benefit, legal conclusions don't really get you anywhere.
Right.
I mean, you can state it generally what you're attacking, but pages of legal conclusions are worthless.
It's not a brief. You're going to have a brief later on as part of your summary judgment motion.
And maybe at your Rule 12 stage as well.
Right. Now, a lot of the so-called Twickball standard is encoded into FRCP 8A. It says a pleading that states a claim for relief must contain the following: a short and plain statement of the grounds for the court's jurisdiction. So you'll notice my jurisdictional statement is 2 lines, right? So short and plain. And next, a short and plain statement of the claim showing that the pleader is entitled to relief. So again, keep it short and keep it plain. You don't need to tell every fact. You'll have a chance to say more later. And then a demand for the relief sought, which may include relief in the alternative or for different types of relief. So you'll see the prayer for relief in a little bit. All right, now let's go to the next section on our template here. Next section is venue. The venue section is not mandatory. You do not have to brief venue. I think most people do it.
I do it every time.
Yes, most people do it most of the time. However, it's not like jurisdiction, all right? If you skip your jurisdiction section, your pleading is defective. But venue, it's not that way. All right, next. Most people will have a section about the parties where they say a little bit about who's suing and who is defending. Next, you have usually your biggest section, your factual allegations. That's where you tell the story of your case, what happened, the who, what, where, when, why, how. And then you may have a little bit of law in there as you try to explain why all this starts to amount to a cause of action. All right. Now, then you have the section where you specify your causes of action. And this is where you have to explain what you're demanding and what gives you the right to demand it. Now,
in law school, we would case brief and break things into pieces. What's required, and at least in Pennsylvania, they had a book called Proof of Facts or proof of Claims, and it was basically, okay, if you have battery, they break into 3 or 4 elements. So your counts, your claims, really need to cover, at least in the allegation form, all of the pieces you would have to prove to be successful on that claim.
Right. When you have your causes of action, you might have multiple, all right? If you have multiple, then you want to say first cause of action, second cause of action. The first paragraph under each cause of action, you need to incorporate prior allegations, all right?
Some people do it differently. I don't incorporate every paragraph because on your second, third, and fourth counts, you're incorporating the first paragraph or first count in the later counts. That's called shotgun pleading.
Right. You don't want to do that.
Don't do that.
So like for your second cause of action, you would incorporate
the factual allegations.
Yes, the factual allegations. You wouldn't incorporate the second or the first cause of action. Right. So in your cause of action section, you want to say a little bit about the law that you're using, maybe state a little bit about why this is a prima facie case for relief.
Yeah, I would label it. So if count 1, you might have 3 Administrative Procedure Act counts. Maybe the first one is arbitrary capricious. Maybe the second one is failure to follow notice and comment rulemaking. I think I like to have something in each count that's descriptive under as a heading that tells the judge, because when you get a motion to dismiss, the defendant is going to address each count individually, and the judge is going to rule in your favor or against you on every count. Mm-hmm. So if you mush all your claims into one count, you risk having that one count dismissed. The more you break your causes of action into individual causes of action, the greater the chance that your complaint will survive a motion to dismiss.
Fair enough. I will say I don't think there's exactly rules on how much you're allowed to squeeze into one cause of action.
You can do as much as you want.
So like you can just say cause of action, APA, arbitrary and capricious, violation of law, contrary to statutory right. Without procedure required by law.
If the judge grants in part and denies in part, you want your best claims to survive.
Right. And as you said, how you structure your causes of action is an organizational tool for your lawsuit. So if you lay out 3 or 4 separate APA claims instead of one, then you're going to have nice separate sections on each one that will make it easier for everyone to identify what you're arguing about and when.
And if it's a mandamus, if it's a delay case, you might have APA delay as count 1. You might have mandamus as count 2 in the alternative. That's great. So yeah, there's you need to think strategically, and you need to view your complaint from the other side that's going to attack it under Rule 12. How are they going to attack it? What are they going to say about your complaint? What could be deficient? And you also want to put yourself in the shoes of the judge and the judge's law clerks. How are they going to view this? And everything I do in litigation, I think, should be geared toward how does this advance me closer to getting what my client wants? So having 3 counts instead of 1 count, if that gives you an advantage, you may want to do that.
Right.
And once you create a template, it gets easier to use it over time.
Right. It's an organizational tool. And I think actually a lot of federal court litigation is about organization, right? When something gets filed online, you get 1 free look. You have 30 days to use it. If you don't use it within that period, then
10 cents a page.
And you later want to access it, guess what? 10 cents per page, right? So you want to use those free looks. You want to archive each pleading as it comes. You want to save the right versions, the right drafts.
You want to serve the right versions.
Right. I have 3 folders for each district court case. I have drafts, and I know that I will never file something from that folder, right? I have another folder called to file. So before I file anything, I will convert it from a draft to a final. I'll put it in to file. So then when I'm checking in Pacer or CMECF, is this the right version? I will immediately know because it will be in the to file folder. I have never misfiled anything so far after filing thousands of pleadings, and I love my system. And then I'll have a third folder called downloaded from CMECF. This is the docket, every entry numbered. Every pleading gets a number, 1, 2, 3, 4. Download each thing in order, start it with the number, so you can read what happened in sequence.
My 3 folders are simpler. Mine's drafting for ECF from ECF.
So exactly the same. That's funny that.
And when you download them in batch, they download by number. It's going to be 1, 1, 1, 1-1, 1-2, 1-3.
I combine
2.
them.
Yeah, and I just rename them 1 space complaint. 1-1 civil cover sheet, 1-2
but it's funny
Exhibit A.
It's funny that we call them different things, but we've worked out the exact same system. So maybe that means that there's
it works,
to what we're
right?
saying.
Yeah. The only problem with the ECF system is that if you're filing 3 or 4 lawsuits from the same court the same day, you may get tired and your computer may go back to the same folder, a different client. I've misfiled client A's lawsuit and client B before,
right?
But not the wrong folder; it was the wrong client.
Motion to substitute pleading, right?
Yeah.
Last section is your prayer for relief or your request for relief.
I'm traditional. I say prayer.
Yeah. A lot of people like to say prayer.
You say both. You say request and pray.
Request for relief, but then I say plaintiff prays for judgment against blah, blah, blah. Now, here you have to specify exactly what you want the court to do. If you don't ask for something, the court can't do it. Right? So here I say, I ask the court to require defendant to adjudicate plaintiff's asylum application within 30 days. Then I ask for EJF fees. You don't really have to specify EJF fees in your complaint. A lot of people do it just, I don't know, as like a scare tactic. I originally didn't do it, but then it's something about everyone doing it. You just kind of fall into it.
But sometimes people ask for attorney's fees and costs, or costs and expenses. The EJF statute doesn't allow for that. It can only get attorney's fees.
Sure. But even if you haven't asked for fees in your complaint,
you can still get them.
And you win a civil lawsuit, you can still get EJF fees.
You're not waiving it.
So this is kind of wasted space. And then lastly, you always want an all other relief section, all right? So whatever else the court thinks is appropriate. That's so that if there's something you didn't think of.
Equitable relief.
Yeah, equitable relief.
Latches.
Some sort of temporary relief. Unless you have something general like this, you can't get it from the court. So you need this. Last thing is your signature block. Eastern District of Virginia has a 9-element signature block. All right. Now, technically, your password that you type into Pacer is your signature. So that's how you sign something.
Only if you're admitted there.
Yeah. So you sign something by entering your password and then uploading a pleading. However, you also need this 9-element signature block. Different places require different things. It's usually in the local rules.
If I have someone who's not admitted there and they're doing proc vice eventually, I'll put their S/S electronic signature and I put with permission in parentheses, because that means I am the admitted lawyer. I'm essentially signing for them, and they have reviewed the document and they have authorized me to sign for them.
Right.
Otherwise, you basically have them sign in ink. Which looks really weird, having one electronic signature and one ink signature. And with habeas corpus petitions, if someone has to verify, it may be that the referring lawyer signs in ink on the last page, and I do electronic signature in the signature block. Because they're not, until you're admitted to proc vice, you're not allowed to use electronic signature. Even really until you had proc vice and you've been granted PACER or CM-ECF privileges, that's when you can use electronic signature. But lawyers do it all the time. They use it everywhere, and they'll use it in their proc vice application. No way. If you're signing saying I've not committed any crimes, I think they want you to sign that in ink.
Yes.
It's a privilege only to those who are admitted to practice, whether full or temporary.
Right. You hardly ever have to sign a pleading in wet ink. Usually it's just /S and then you write your name. Yeah. And that in conjunction with your CM-ECF
is
password,
enough. It's under Rule 11. You are committed for every purpose that an ink signature would be for. It's just the lawyers who are not admitted, they take it for granted.
Right. So if you give your paralegal your password, remember she's signing things for you.
Yeah, everything they do is on your head, not theirs.
Yeah.
They're not licensed. They're not liable. And actually, the example wasn't immigration. What I was thinking earlier were the people challenging the 2020 elections. There was a lawyer in Michigan that was close to being disbarred because he didn't review any of the filings. And they were going after all of the lawyers for contempt up to the Sixth Circuit. And this guy's like, I didn't read it. I'm just a local lawyer. And the answer was no. You are on the hook for everything that was said in every single one of those complaints.
Yeah. And we didn't say this, but even when you're just local, you have to be prepared to argue the case. You have to know the whole case and be able to negotiate on behalf of your plaintiff.
Yeah, a lot of the judges' standing orders will require that at least one lawyer appears that has full settlement authority, understands the facts of the case, and is ready to go forward. And you're not out of that case until the judge grants you a motion to withdraw. You're not going to get that as local counsel unless the case is resolved or you're replaced by another lawyer. So when you're charging your fee, you're taking on responsibility ethically for that case.
Right. Where can you find good sample complaints? We mentioned the AILA Pleading Bank.
Actually, the court website.
Court website sometimes has sample. They have a habeas template.
Definitely. Habeas.
Let's see. And then some nonprofits will often put out templates like NILA, the National Immigration Litigation Alliance. Great organization. They will post templates from time to time.
The American Immigration Council doesn't do complaints, but they have wonderful practice advisories that you can use to really build. They have a practice advisory how to avoid dismissal under Rule 12.
Yes.
How to construct a complaint. They're not giving you the complaint, but they're giving you the guts of the complaint.
Right.
And AILA has a great brief bank, as we discussed earlier. And also, if you see a published decision where someone won, Westlaw and Lexis and Fastcase, they can be good case finders. Then you can go to the docket, and if the case is not 465 category, you can download the complaint, and you can't use it as exactly a template, but you can cut and paste and do it from there. Or if it is a sealed document, you might be able to reach out to the lawyer on the docket and ask them, could I get a copy of that? If you're rich and you have Westlaw, you can get the actual filings from Westlaw, but they're charging you per document.
Right. So that's what I got about complaints. Anything else, Brian?
No, I think we covered a lot of detail there.